All right, everybody, welcome back to the House Committee on Government Operations and Military Affairs. We are in our second part this morning, returning to conversations about S-17 and act-related sheriff's reforms, and have a couple of our team from the Department of State's Attorneys and Sheriffs. And so if you would both like to introduce yourselves, and thank you for being here today.
Great. Good morning, committee members. Nice to see you all. My name is Annie Noonan. I'm the Director of Labor Relations and Operations for the Vermont Department of State's Attorneys and Sheriffs.
And I'm Roy Tebow, an attorney currently working with the Department of State's Attorneys and Sheriffs. So, with that, obviously, S-17 has gone through a lot of iterations, both on the Senate side, and now we're looking at amendment version 1.2 here on the House side.
Which we, just so you know, that I circulated some language that is not something we're presenting. So
okay.
It's just, there are some ideas for consideration, but the committee doesn't have that. I'm not putting that on the table yet.
Okay, thank you for the clarification. Nevertheless, we're happy with the direction generally that S-17 is going in. And there are really four principles that have gotten internal discussions in the department. It's looking at how can there be greater accountability within the sheriff's organizations? How can there be transparency in terms of contracting and finance? How can we ensure professionalism within sheriff's departments? And also, how can we do some things to modernize the statutes that govern and regulate them? So turning to a different language that is out there, we'll start with under Section 2, focusing on duties and what happens when you have transition with the sheriff's department. This is one of those areas where accountability is key, making sure that the property and resources are continue to be held by the sheriff's department, and that cannot be squandered away, liquidated into bonuses or other things like that. The role of the assistant county judges, or the side judges as they're colloquially called, is important as a check. They have control over the treasury for county government, and here we are supportive of a plan that entails the side judges continuing to have an active role in maintaining the plan for disposition of any property when you have a lame duck sheriff, and also making sure that that plan, when completed, is then turned over to the auditor of accounts for its reconciliation with the finances of the department in the long term, and likewise that the assistant judges maintain a record of that as well. We believe that that ensures a greater degree of transparency, and also will have sheriffs during that lame duck period maintain a modicum of accountability, and also ensure that they continue to act in the public's best interest and in the best interest of the long-term success of that department. I'll pause there if there are any questions on.
So one question that has come up, so we're talking about the period when a sheriff has said, I'm not running for re-election, or and so there's this, the S-17 contemplates that there be additional potential for audit in that time, and also the sort of need for two signatures of sign off. One of the conversations that we've had is about the filing of a plan for, you know, if there are assets that are being sold, where you mentioned a few of those examples. So the question I have is the side judge the best, the assistant judge the best positioned sort of independent official that's at that level? Or should we consider that sign off could come potentially from like the sheriff's executive committee or some other entity that isn't directly involved but might have more insight into what's an appropriate expenditure or a sale or something that might be happening, versus I don't know how much in some communities the side judges will really have insight and be able to sign off on some of those decisions. So that was a question that's come up.
Well, I think that's a key issue, which is, do the assistant judges actually know that they have, you know, that power? And I think what confuses the issue is that sheriffs really have three distinct funding streams. They have a state funding stream, a county funding stream, and then their own contracts. So that really makes regulating the entirety of sheriff's department difficult. So the Department of State's Attorneys and Sheriffs right now is limited really to supervision over state transport deputies, and, you know, very limited level of support to the sheriff's departments. Likewise, one of the reasons this bill has come about is because of concern that the third prong of funding, that being the contract funding, is really just left to one statutory section and then discretion of the individual sheriff's departments about how they regulate, manage, and pursue those contracts and then use those funds. I think the argument for the assistant judges to maintain that role, there may be an education requirement for them to be familiar with what they need to be looking for or concerned with. But ultimately, they are also elected leaders who are selected by the populace of that particular county and control at least some county funds and county money that is distributed. So they already have a fiduciary relationship to the county. They are elected popularly by the citizens of that county. And it seems that they are best situated to understand and assess what's going on with law enforcement in that county and also what the mood of the public is about how operations are going there. So in a situation where there is no one single player in state government or county government to do that, they seem to be maybe the best fit, for lack of a clear choice.
I think one of the things that would be helpful, though, is the side judges would probably need some training in terms of what are the bills that have to be paid. An outgoing sheriff, still, we wouldn't want to be in a situation where things were being sold off and to the extent that payroll can't be made and, benefits stop because they didn't pay premiums on health insurance. So there would either need to be some really clear directions to the side judges, or these are the things you need to make sure are happening. Or it could even be the side judges in consultation with the Sheriff's Executive Committee. I think about a time back down in Wyndham where the other sheriffs came to the financial aid of the Wyndham County Sheriff of Wyndham. So they had obviously a vested interest in making sure, and part of the reason they did that is they were making sure that the department was able to do things like make payroll. So I guess I'd throw those 2 points in. That I don't necessarily know that all the side judges recognize what their role is right now today, as we saw in Orange County, where they said, well, we didn't know that we should be watching what was being sold off. Number two, they would definitely need some review and training and maybe short guidelines as to what they need to be looking for. And then maybe they should consult with the Sheriff Executive Committee if it's not clear. Some of the sheriffs going out are just basically handing over the front checkbook, and there won't be any issues. But if there are issues, the side judges may or may not know, and they may need some guidance.
I like the language that you use around in consultation with, because if it's the side judges in their, elected role and they're down at the county level that are signing off, but they've got a clear legislative guidance that they should consult with the sheriffs who aren't in that county, but are, the experienced people that the sheriffs have elected to the executive committee. That might be a way to sort of square the circle, and I'd be interested in hearing the sheriff's position on that, but we should definitely, I'm thinking that might be the best way to pull in the right voices if there is any.
I think that assures some subject matter expertise then about what would be normal to wind down during the end of a sheriff's tenure versus what would be something out of the ordinary. With that, we move on to discussion of audits under Section 290B. There are a few areas that we thought there could be some further enhancement or clarification. One is in subpart 9, which concerns procedures about notifying the auditor of accounts and department about participation in non-public organizations. And there's been at least one, I think, fairly well-known example of a sheriff participating in an external organization that was really supplementing the efforts or trying to collect its own source of revenue to bolster sheriff department operations. Right now, that's the language that we've seen in draft form talks about where an employee of the sheriff's department or the sheriff him or herself is a director in an organization. We think that should be broader to include participation, knowing that there can be sometimes a compulsive or coercive effect, even if just a sheriff is sitting as part of some ostensible nonprofit or other organization trying to funnel money to that department. So that's a fairly minor change, but we think that a broader view is appropriate for the limited scope of cases. And additionally, in subpart, we'd actually like to have an addition to subpart E of 24 VSA 290 E, 290B, then parenthetical E. Sorry, it's a little confusing. We thought that it would be appropriate to expressly provide that an appropriation shall be made to the Department of State Attorneys and Sheriffs in support of the annual department audits. it's one of those, it's a technical thing, but it's, I think, important to make sure that there's not an unfunded mandate to do this, given that there may be more audit activity than historically there. So even if just signaling by this committee or appropriations, as it may be, we think it's important to ensure that that's sustainable in the long term and that this isn't a priority right now while there's a lot of attention on the Sheriff's Department.
We currently have a line item in our budget to support audits, which are the audits that occur to the sheriffs every other year. So we actually have an audit line in our budget. We estimated that if the sheriffs have expressed concern about being subjected to costs that they don't have. So we thought about what would it cost to put enough money in the budget to cover those, so that if the auditor of accounts said, I don't like what I'm hearing over in this county, I want to take a look, we might be able just to support that with additional money to the audit line in our budget. I think I estimated with our financial person, Barb Bernardini, about $120,000 additional.
Representative Marucci has a question.
This is something that has come up as we've been talking about the whole concept of audits. There's different levels of audit. Are we talking about a full audit? Just an audit report?
So what happens is that every other year there's a full audit
Okay.
for the sheriff, and the next year it's basically a mini audit, I want to say. I don't know how Auditor Hoffer calls it, but it's a mini. Sheriff Anderson might be able to answer what they call it, but we call it sort of like a very minimal audit. Put your books in, we'll take a peek at them.
What's the current line item? So $120,000, I think would be a big increase in that, if I'm remembering correctly. Right?
But we have to check on that, but I'm going to say I think we have about 60 or 80,000, but I'll check and get back to you. I'll send an email.
Okay. And that was the extent of our comments or recommendations with respect to Section 3 at this time. Section 4, concerning conflicts of interest or the appearance of conflicts of interest, is an area also ripe for discussion. The House and Senate GovOps committees within the past few years have promulgated and put into effect the state code of ethics and the apparatus for that. One of the things that was concerning from the Senate passed version of S-17 was creation of almost a parallel organization or some parallel standards that would only really apply to sheriffs, and we put a substantial burden on the Department of State Attorneys and sheriffs to then regulate how that worked. This was an area where we felt that there's already an existing system that covers many other state officers and employees, and that adaptation of the state code of ethics or application to sheriffs was more appropriate than creating a standalone basis. We also believe, to get a little bit ahead, that the adherence to that policy provides clarity and consistency, and also might lead to some reconsideration of changes made to the use of the 5% funds, given the potential adoption or requirement in statute for use of model policies, along with then more robust auditing, and then of course the applicability and consequences of being subject to the state code of ethics. So our proposal really focuses on integrating the state code of ethics and applying it to sheriffs, and then limiting the department's role to being a recipient and more or less have responsibility to vet and then forward those on to the state ethics commission if appropriate. Some of those complaints, of course, could logically be sent back to a sheriff's department if it's a complaint, let's say, about a deputy sheriff, where the sheriff may be able to internally deal with that through discipline. But the circumstances where it's the sheriff, him or herself, that may then require forwarding on for a formal investigation. But we believe that that's a robust and strong organization that could handle that type of work. And again, it makes sense that as constitutional officers, sheriffs be subject to the same standards as the Secretary of State or the Attorney General or the Lieutenant Governor and so on.
Is it possible that, and this might be more of a question for Deputy Director Simon, or excuse me, Director Simons or Chair Sorrell, but if we went with my concern, and this came up in testimony last week about just going to the state code of ethics, is that enforcement and accountability piece is a little bit vague. Like, we haven't really seen in its current construct, the Ethics Commission be able to do much more than make some recommendations. Oftentimes those are really useful, and just making and having just the exposure is enough to create some accountability for certain practices that I think the public would have concern about. But in the case of some of the behaviors we've seen from a couple sheriffs over the years, I'd wonder if just going to the state code of ethics, if there was a serious enough violation, if that in and of itself could trigger a referral for decertification with the Criminal Justice Council. I guess that's what I'm thinking is, do you think that if we go to a construct where instead of this conflict of interest policy that's in the Senate has passed, we're really looking at just bringing the sheriffs under the state code of ethics, if there are really serious ethical complaints, would those just go back to the department? Because if it's the sheriff themselves, it's one thing if it's a deputy, as you described, Roy, but if it's the sheriff, it's the leader, the constitutionally elected officer there. What's the sort of next layer of accountability if it's a really serious complaint?
Right. So I think two things are important, of course. It's both the decertification proceedings or potential decertification proceedings through the Criminal Justice Council and also the state ethics proceedings don't preclude pursuit of criminal prosecution by an appropriate entity or investigation by an outside organization. And, this is pretty clear in all the sheriff misconduct. I think the commission's aware of. It's typically been the Vermont State Police that come in to investigate, and then either combination of local or conflict state's attorney taking on that role, or sometimes the AG's office being involved. What I will note is that in going back to Section 1, Category B misconduct through the Training Council purview already includes misuse of official position for personal or economic gain. So that covers a broad range of the type of financial irregularities or ethical concerns that could trigger a proceeding from the Training Council. And then the proposed additions of subpart H and I include gross negligence or willful misconduct in the performance of duties. I think that my interpretation would be that could include financial irregularities or other mismanagement of the department. Likewise, abuse of the powers granted through law enforcement certification under Section 2358 of this title could also apply to some circumstances where there's unethical behavior or misuse of an official position for some sort of private or personal gain.
Okay, so one of the things that we ran into, I'm asking the committee to go way back. I've been talking to legislative counsel to try to find a way through this. But one of the things I keep coming back to is that what I would really like to have us see in the future is the ability when there's a serious criminal charge for there to be a pause, a suspension in the sheriff's authority and have somebody step in pending the outcome. And I've asked, legislative counsel and put Mr. Devlin through several rounds of trying to work with, our team here to figure out a way that doesn't violate the Constitution for us to have that layer of accountability. And I'm wondering if we have an incident where we have a sheriff who, for instance, is charged with embezzlement. This is something that we've, the kind of case that we've had in the past. So it's not just hypothetical. There isn't, short of them being imprisoned under current statute, there isn't really a way to suspend their ability to move money around or continue to affect, the benefits or the duties of their deputies. So, I feel like I keep running up against, I'm in this little box where we're talking about things like side judges signing off on stuff, and what we're really faced with some of these cases is a much bigger challenge.
Yeah. So a few things. I think certainly we're aware of the constitutional concerns about the limits of the legislature to regulate a constitutional officer such as a sheriff. But that being said, of course, the longstanding principle is no person can or should be above the law. And I'll give some examples. So I was till I was done with my term, I was the lead prosecutor and former Sheriff Peter Newton's case. And we had substantial concerns from law enforcement and prosecutorial side about the ability to use that office to potentially interfere with the rights of the victim in that case, to persuade or interfere with other witnesses, for example. And that really comes from the power that's vested in a sheriff as a principal law enforcement officer in a county. We also have concerns about possession and use and access to firearms. In that case, we sought and obtained from the court conditions of release, which did several things. One, precluded handling of firearms by Sheriff Newton. And I'll just clarify, of course, all this is public record and in a public hearing, and there's court documents that substantiate this. So I'm not disclosing anything that'd be out of turn. We also had argument about to what extent could the court inhibit or limit the law enforcement duties of the sheriff. And where we reached was language that precluded the exercise of direct law enforcement duties. So that would be going out on patrol. That would be carrying a service weapon as part of duties. It left really the administrative functions of the sheriff intact. So things like approving payroll or dealing with hiring or other things that don't require a law enforcement certification. So if you kind of look at those two things, that there are things that a sheriff does that are principally law enforcement activities that require certification from the Vermont Criminal Justice Council versus those things that any person could do without having such certification. So that was the order of the court that precluded him from carrying a firearm and from exercising law enforcement duties during that time period.
If that time period was conditions of release, so there have been an arraignment, but not yet a conviction?
Correct. So he was arraigned. The probable cause had been found for multiple offenses, and then the case went on and is, as of yet, not resolved and is pending trial.
And the flip of that would be if you had somebody who had been charged with embezzlement, you wouldn't want them doing administrative duties. You wouldn't want them handling a checkbook, approving timesheets, doing anything with relationship to money. And of course, embezzlement, in that situation, perhaps you could have said, he's being charged criminally, so there's a criminal charge pending. But administratively, Judge, we don't think that this person should have any ability to oversee administrative responsibilities either, even in terms of hiring, because the person's proven themselves at that point, or potentially that there's inappropriate decision-making going on in terms of the functioning of the office.
Interestingly, we talked about conditions of release, so I know this is not judiciary where everyone hears about them all the time, but 13 VSA 7554 lays out two different criteria or two different sections that a court considers when fashioning conditions. One deals with risk of flight. The second part is about ensuring public safety, and that's really where a lot more of the debate takes place. Right now, there's a provision, it's subpart A to E, and this is limited, as Andy just mentioned, to embezzlement. Right now, our statutes allow for a court to impose a condition that allows for the suspension of an officer's duties in whole or in part if the defendant is a state, county, or municipal officer charged with violating section 2537 of Title 13, and the court finds it necessary to protect the public. So that statute is a particular embezzlement of public funds. One of our proposals is to broaden that, given the precedent set here, to clarify that the court, when dealing with any law enforcement officer who has committed or has been found, probable cause has been found to have committed a crime, not limiting it to just embezzlement, and the court finds that doing so, that is a suspension of their duties, it's in the interest of justice. So there are a lot of, obviously there's a huge discussion about law enforcement accountability and misconduct, and public trust is not necessarily always the same as public safety. So there are maybe policy questions or considerations that the legislature could consider about granting the court authority with appropriate findings to suspend those law enforcement portion of duties, which from our perspective is distinct from removing someone from office and is not tantamount to impeachment.
Okay, so, boy, I just want to make it really clear that the department's position is that, if a court finds probable cause, that they should be able to suspend the duties of a sheriff temporarily until the issue is resolved, or until the sheriff would be, impeached or exonerated.
I think if constitutional considerations were not on the table, that would be completely logical. And looking at the other things a court can do. So if, let's say, a sheriff is accused of committing a aggravated assault with a deadly weapon on somebody, the they shoot a neighbor. If that person were not a sheriff, we'd be looking at the standard, panoply of things. Should that person be held without bail because of the danger that they, pose to the public? Are they a flight risk? Should there be bail involved because of their potential to leave the state? And then other conditions. If you have a firearm-related incident, probably 99% of times, courts are going to issue an order saying this person should not have a firearm pending the adjudication of the case. There can be other things, too, that are restrictive or could preclude somebody from exercising their duties. A 24-hour curfew, for example. Courts can issue a curfew and not allow people to leave for any exceptions, although frequently there's legal, medical, or work exceptions that get worked in. But the court has very broad power in setting once probable cause for a charge has been found to tailor conditions that satisfy public safety. And, applying that back to law enforcement defendants or a sheriff, they do have heightened authority and responsibility because of the power to arrest, the power to, carry weapons, the power to enter, homes under exigent circumstances where we as regular, citizens could not. So balancing, the public safety analysis can be somewhat different when you're dealing with a law enforcement defendant versus someone else. And just to add, I think that Senator White, when she testified, noted that accountability is one of the things people are really hungry for when looking at the reform of the sheriff's profession. And I believe it was in her testimony that she pointed out that already 24 VSA section 294 addresses circumstances where a sheriff is imprisoned. And again, none of us are constitutional scholars, and we'll defer to those who are, but the legislature has had on the books for years now, effectively finding a circumstance where the sheriff can be suspended when he or she is incapacitated or can't discharge duties. That would be when they're in jail. Are there other circumstances where someone can't discharge, their duties because of a court-ordered condition or infirmity? Or what do you do if a sheriff is arrested and held out of state and is physically not present or able to discharge their duties? There's any number of circumstances that seem illuminated by that existing statutory authority. If this committee considers further any questions of suspension, from a logical standpoint, there should be something between doing nothing and then the ultimate option of impeachment. Noting, of course, too, that impeachment can sometimes run into hurdles of a prosecutor, let's say, not wanting to extend immunity, which would preclude that person from being able to present a defense to the House or a trial before the Senate. But suspension is a different concept than a removal from office, especially if that remains a compensated position or there's some, limited duties that remain under such suspension. The temporary nature of it, making things contingent upon whether the House does or does not initiate impeachment proceedings and maybe putting a clock on that time period so there's some period to react and respond. But what I think is untenable is to have sworn law enforcement officers who are not really accountable to anyone other than voters discharging duties while they're facing very serious charges. And that's not a conceptual issue. It's one that we're dealing with even to this day in the state.
So we've heard pretty loud and clear from Legislative Counsel that the suspension, even a temporary one, gets us into pretty murky territory constitutionally. And I share the assertion you just made is something that I've said in some version, probably several times on the record here, that it's pretty extreme that even when there's been a crime committed, there's not any interim recourse that until the matter is completely settled, whether it's criminal impeachment, that we don't have a whole lot of power, and even the decertification and that process leaves all of the administrative duties of the sheriff intact. Another question that I have, and this might not be one for you, it might be another one for the Criminal Justice Council, is the existence of a pending criminal trial. So if there has been probable cause and there's been an arraignment of a sheriff, even that in some ways would preclude the Criminal Justice Council from doing their own investigation and decertifying, as I understand it today. I mean, there's a hesitation for them to do anything parallel. So then you end up with a situation where, because somebody has been charged with a crime but hasn't yet been convicted, that we're actually delaying the decertification potentially.
I think that hesitation is the key word there. And, it does come down to questions of whether the prosecutorial agency wants to extend, immunity, or can create a circumstance where one thing for sure is that the Criminal Justice Council proceedings are held confidentially. I think the main goal is to not taint a prosecution, and likewise not taint that process. So if a sheriff comes in, provides a defense, making sure that the information there does not leak back and taint the prosecution or impact the defendant sheriff's rights in criminal court. So that's a complexity, and that's, I think, drives hesitation, but it's not an absolute bar on proceeding, and there are ways to deal with that. Garrity
You're showing Garrity warning, Garrity writes to someone that basically says any information an employer is doing an investigation where there may be criminal implications, so it can Garrity up, that term, sort of Garrity up the person, so that any information that they take in can't be used, can't be turned over to a criminal prosecution. That information has to be found independently of what the employer found. So there is already, that's a U.S. Supreme Court ruling.
One other friction point with the constitutionality analysis is that the Constitution is fairly sparse in defining what sheriffs do and what their roles are, whereas the duties of the sheriff are really a construct of statutory law. So already this bill, S17, is looking to amend Section 290. So one alternate path the committee could explore is, having contingencies based upon what a sheriff's duties are, based upon either their level of law enforcement certification or other qualifying circumstances. And again, the constitutional law experts may disagree, but I want to empower the committee with any idea to try to expand that. And again, it doesn't make sense that so much is left to the legislature to define in terms of scope of duties, yet not have the ability to then restrict or identify circumstances where there could be a limitation on duties.
Okay. We'll have more questions for legislative council on this, I am sure. But I appreciate the department's position on it, because it's one that since we started these conversations months ago, I've been wrestling with, and this committee's been wrestling with. So, did you have further testimony on other sections of?
Yes, and I can be brief given the time. So moving on to Section 5, a fairly complicated one in terms of dealing with, the big question here of really what are we doing with sheriffs and contracts, and what degree of accountability is necessary. I think that Chair Anderson already testified before the committee about what, I think everyone's probably exhausted of hearing what 5% is and what it can be used for. But the question remains is, if other, and the departments consider this, if there are other safeguards, such as those that are contemplated or have been discussed, about the adoption of model policies, about expanding the staffing and oversight of the Department of State's attorneys and sheriffs, about being subject to the state ethics code, for example, and then having model policies, particularly dealing with compensation and benefits. Is there as pressing of a need to actually reform that? And looking at it this way, it's changing how that can be used may substantially be mitigated or addressed by including those safeguards that deal with transparency and accountability and have real consequence or ability of other outside entities to react and detect malfeasance if it's occurring. So that's a big policy question for the committee to consider. Certainly, our understanding is that the sheriffs are generally the view that that is the preferred option versus changing the ability to use the 5% of what they administrative overhead from the contracts as they are able to do now. Just some other things as well, of course, is that when considering, who can be involved in the development of model policies, right now, the Criminal Justice Training Council does not generally have policies or deal with the regulation of finances in law enforcement departments because they're generally looking, and this would be on the conflict of interest policy as well, but they're generally looking at municipal or state entities where the executive, whether it's a chief or the colonel in the case of state police, don't have direct control over the budget and rather are having that program from a legislative body and are not in the business of going out and generating their own funds. So we're not sure that the council is currently situated to really be the correct place to generate those policies. The other point as well is, the term model policy is out there. And the question is, and Sheriff Anderson can probably speak to this better, but obviously operations in Essex County are fundamentally different than they are in Windham County. And one size fits all may not always be best. And there's some concern within the sheriff's departments and membership that making a model policy compulsory can have some significant drawbacks, but having guardrails from which they can, base their own policies on may be appropriate. That comes, of course, at the expense of then having potential for a little less consistency from what the legislature may desire. We don't have a direct proposal on that, but we do want to note that making sure that there's clarity in terms of what is a model policy versus those that should be compulsory or are going to be required would be helpful for the department and the sheriffs in terms of navigating reform. The really final point I will make is there's been some discussion about modifying or cleaning up some of the language around who is a state employee within the sheriff's department. Presently, it's the state transport deputies. There's also the contemplation in the bill as 17 is passed to include mandates concerning court security, also looking at the requirement to assist victims of domestic violence or individuals who receive an RFA, have their property managed. So 2 points on that. The unfunded mandate portion of the assistance to individual plaintiffs in the RFA is problematic, and we'd be looking for some language to clarify an appropriation to either the department or some other entity that the sheriffs could seek reimbursement for those services that are rendered. And in terms of transport deputies, Section 290B and 296 both deal with this. And this is a broader conversation about what proceedings should the state transport deputies be used for. And one thing we would like to see come out is clarity that those state transport deputies should only be utilized in cases where the state of Vermont is a party to the proceeding. So that covers criminal court proceedings, youthful offender proceedings, CHINS proceedings where a juvenile is in some sort of custody and needs transport, and then also mental health proceedings that are initiated by the state of Vermont through the Commissioner of Mental Health. Beyond that, there are other circumstances where people may be transferred to court that's historically or traditionally been done by the Department of Corrections. I think due to some of their staffing and policy concerns are less frequently be able to do that, meaning some courts have tried to look and pigeonhole or compel the state transport deputy program for issues where the state of Vermont is not a party. So that could be civil proceedings or other things. And our department's concerned that as the courts are working through backlog and courts can fully open, the level and volume of transports for core functions such as criminal court has really gone back up and returned to getting closer to pre-pandemic levels. So allowing or clarifying that if the judiciary wishes to have someone who's incarcerated at a civil or hearing where the state's not a proceeding, that they could contract with the sheriffs and they could provide transport outside the scope of the state transport contract or contract with the Department of Corrections. That's getting into the technical end of things, but we think that's important to make sure that scarce resource of transport is used in the most prudent way to support the court cases.
Is that particular issue addressed in all in that 17 as it passed? I mean, I know we kind of touched on transport deputies, but the clarification when used, unclear. That was.
I don't recall if it came out of the Senate bill as it came across, but we've been talking about this sort of just recently has been attempted to be dumped on the department, and our transport deputies are dealing, as Rory said, with moving people for their criminal proceedings or their CHINS proceeding, whatever that is. And an example that Rory gave, which I think is really instructive, is, if somebody in a facility, somebody's incarcerated and they were in a car accident, 2 years ago, and they're suing Allstate Insurance Company, and they have to get to court, they've decided, why would a state transport deputy have to manage getting that person to court for that proceeding? It has nothing to do, the state of Vermont is not a party to that. These are state employees being paid by taxpayer funds. Why? And we don't have the capacity. We truly do not have the capacity to manage this. And when this first came out, the conversation about, you're going to start doing this, and I contacted DOC and I said, we have no capacity to do this. We have nothing in our budget to do this. We didn't anticipate any of this work. This has always been on DOC. And it's just not really a state, the state of Vermont is not a party to this. These are state employees doing work for the state of Vermont and not for private lawsuits.
And just for context, I don't believe this is in the original or the Senate passed version of S-17, but it was an important consideration when we started talking about the oversight and administration of the sheriffs and what resources internal to the department are needed, what things could change, and then also how do you account for and audit those expenses. And that was a concern of non-traditional transports coming into that funding stream, of what that means in the future. The final point to make is really looking at the proposal for an oversight task force and report. Ultimately, because of some of the things that are on the table to be considered, the need or the scope of any report or callback could change, particularly if there is a mandate for the adoption of model policies already in statute. If there's applicability of the state code of ethics, some of the questions that are being presented are going to be resolved by the legislature and not really needing further analysis. Ultimately, in consultation with the sheriffs, our department's of the belief that if there is a report, our preference would be that it be the Department of State's Attorney and sheriffs being tasked to provide a report to the legislature at some point in time, and that the legislature identified parties or entities with whom the department is required to consult. And certainly the list of agencies like DHR, the Sheriff's Association, DMH, the State Auditor, the Criminal Justice Council, all things, and of course the county assistant judges who we've been talking about today, all make sense for further changes. But the consensus was that was something that could be undertaken internally, specifically because many of the remaining questions would result or really be geared towards the adoption of policies and resourcing for the department, not the overall statutory authorities that are applicable to sheriffs.
I think there's 2 points. One, I may have mentioned this to the committee once before, but the state auditor's manual in terms of fiscal oversight and how the sheriffs conduct all of their fiscal work is really, it's done. I mean, it's been in play for years. It's an excellent policy and model. And most of the sheriffs are following that. Their bookkeepers and their administrative staff are trained in it. By the state auditor's office did some Zoom calls over the course of the past few years. It's really, I could feel like that there are areas that, particularly there was a question around the 5% where we talked about making sure it's really clear what it should or should not be used for. That's fine. And I think the auditor would agree with that. But in terms of sort of day-to-day fiscal operations, it's a great policy. I think that the Criminal Justice Training Council has a lot of work that they're doing and have done around training of law enforcement officers. I feel like that would be a big section of what this proposed committee would be doing. And again, I feel like that's kind of reinventing the wheel. We have really excellent guidance from the Criminal Justice Training Council about training of law enforcement officers. And I think that those areas here, whether it's ethical considerations or it's around the 5%, I feel like those are the kinds of things that the department could be doing. And I come back to the term in consultation with all these other groups, but spending, having this large committee to talk about a bunch of things that are already being reviewed by the auditor or the Criminal Justice Training Council or by courts or by this legislature. is probably not necessary.
It sounded like from what the Senate's conversation was about this was that and just reading the plain text of this section about the oversight task force that they created, there's a real desire to look at sort of what do sheriffs do? What do we really want sheriffs to do? How should they be organized? What should the oversight be in a much broader context than just the development of model policy and some of these administrative functions? And so I struggle sometimes with, are we trying to figure out the future of how we want to deliver public safety well here? And is that colliding with some of the other reform efforts that we're making and the sort of evolution of the Vermont Criminal Justice Council? We passed 2 bills already out of this committee about the Vermont Criminal Justice Council in support of their work in sort of evolving the training and accountability efforts for law enforcement. So I don't want to duplicate those. So I hear that loud and clear. But I guess what I would ask is, would you recommend, if we do anything like this, if we're tasking the department or the department in consultation with some of these individuals, do you feel that there is a need for us to look at the structure of the office of sheriff and how it's administered throughout the state? Because every time we have a conversation about this bill, I think about things like what the sheriff's doing in one county and the neighboring county are completely different. And we've almost incentivized that with the structure we have. I mean, is it the department's recommendation that we only focus really narrowly on considering policy for, administrative functions and things like compensation and benefits? I mean, or should we be looking at sort of, is this the right way to deliver these public safety functions in the long run?
So I think a threshold, that's then a conversation that really goes beyond just sheriff's departments, which include public safety, the municipal departments, or a lot of other stakeholders that aren't contemplated here. And understanding that, so I'll give my experience from Washington County. Washington County is, one of the mid-sized counties in the state, and we are fortunate to have a number of municipal departments. So they really take over most of the day-to-day policing. And the sheriff's department fills in some traffic contracts, the transport of people to and from court, and some just general law enforcement assistance. So not saying whether it's a good thing or a bad thing, there isn't a huge role for the Washington County Sheriff's Department because the areas where we have dense population are covered by municipal departments, and then state police cover other areas. It is a completely different story in other counties where your sheriff's department is effectively the only law enforcement entity there. So our most rural counties, Grand Isle, Essex, are almost completely reliant upon the sheriff's department. And then other communities in Windham County, where Sheriff Anderson is located, some of those communities, in lieu of creating their own municipal departments, have elected to contract with the sheriff for law enforcement services. So one thing I think I can say safe on behalf of the department is flexibility within the statutes can have its drawbacks, but that flexibility is what enables the provision of these essential public safety services in a manner that serves constituencies. And ultimately, we can hope that voters make informed decisions, but certainly a lot of the sheriff's races around the state this year were in fact contested. And that's a healthy sign that there are different or competing visions of how to deliver those services being presented to voters. And ultimately, there is the check where every 4 years, everyone has the choice to select new leadership if they so desire.
I think from any review that the department would do in consultation with other groups would potentially raise some ideas. We know now that it talks about sheriffs with general law enforcement duties, with processing civil process. We know that they have some specific duties in the statute, transportation of prisoners and juveniles, and so we know that there are some things. If in those conversations, the department and other groups where things are highlighted, I think we would put that out for people to consider. But again, as Rory says, that it's very different in Chittenden County than it is in Grand Isle County, where that is, Sheriff Allen is the law enforcement for that area. And if somebody's kicking your door in at 2 a.m, you're calling the sheriff's department because state police are 45 minutes away.
Or more.
So I think we have to look at, I think to your question, Mr. Chair, I think that all good ideas can come through the process. And I think we would be really working towards making sure that we don't have blinders on, that we're looking at and hearing from other people as to what they want to see. But some of it may already be there. A lot of the stuff that Rory's pointed out this morning, where he said it's already in 290 or it's in here, it's there. I think it's a matter of just making sure that we really do know what's already exists and where the big gaps are. So it's just my thought about this. I don't feel that the study committee is necessary in the way it's set up here.
Do you have any testimony on other parts of the bill before I ask you a couple of questions about the 5% pieces?
I was going to address 5%.
Yeah. Let's get it out before we wrap up.
I keep looking at my phone now because I'm being, I was reached out at one point before today to my former finance commissioner over the Department of Labor. And I think I had testified to the committee about the state of Vermont when they accept contracts or grants, what do they do with the entities that they have, what do they charge? And I think it's so if you look at the 5%, and I want to say what I'm about to say doesn't in any way suggest that you shouldn't look at what a sheriff should be able to do with 5% or how much they should be able to award in any area. So given that, but some people have said, why can they do that? So if a sheriff does a contract for services and they commit, let's say, to a local hospital, making this up, to provide some security, and they commit 2 staff people to do that. So in that contract that they're writing, they're charging for that employee's time. They can charge for, if it's full-time, they can charge for the benefits, the salary of the benefits, the use of the car if the car goes over, a portion of the person's liability insurance or things like that. So the sheriff can write a contract that is recouping the costs. But ultimately, that contract and the performance of that contract, because hopefully there's performance measures written into the contract for the sheriff. Ultimately, the sheriff is responsible for ensuring that the contract is all the guarantees are met, that it's staffed. The sheriff owns, the overall negotiations with their general liability company, with the worker comp and all of that. The sheriff has a lot of stuff that goes into giving a body over to do some work. Similarly, in the state of Vermont, I was thinking about this. I know that when I was serving over at Labor Commissioner, that my salary was charged to most of the federal grants that were brought in, a portion of my salary, not all of it, and of the general counsels and of the director of that program, even though none of us, let's say the 3 of us, none of us did the work for that contract, but ultimately we were considered to be responsible for the performance and the staffing and all of the things that were required. So interestingly, when I was reached out and I asked about what do we, my question was, remind me how much we were charging into sort of that stuff. And I mentioned that this was in relationship to the 5% of the sheriff. And this is what came back to me from our finance director there. Most indirect rates are typically much higher than 5%. In fact, the federal government's de minimis indirect rate is 10%. And he quoted the language for me. VDOL's current indirect budgeting rate is 18% of salaries. Our most recently submitted proposal is asking for a budgeting rate of 23% of salaries. As an aside, when I worked at UVM, and this is the person that's writing to me, it was common to have UVM have an indirect rate of 52% of a total award. So the quote here then talks about the de minimis rate of 10%. Now, what is that? What does that provide? Why can a state agency charge the federal government a de minimis rate of 10% or more? basically because what the theory is that the people who are in charge of that contract and ultimately responsible, part of their salary is that they should be spending some time on that program and watching that program. That's what I did at Labor. I mean, all of the grants that we were taking in, the Vermont Department of Labor is 92% federally funded. Most of our money is coming from a bunch of different federal grants. But ultimately, it was my responsibility every week to be watching how the performance of those grants was going. Did we have people doing what they said they were going to do? So we were being paid by the federal government to do some work. So in essence, the 5% of, ultimately, how does 5% come into these contracts? It's similarly the same thing. So in essence, that sheriff's time this is a portion of that sheriff's time. Now, again, I want to say very clearly that I completely support the committee's review of or consideration of saying what can be done with that 5%. Clearly, you want that money to be used most preferably for the benefit of the citizens and the department. In this, where, for example, the one thing I have some concerns about, where it talks about it cannot be used for retirement contributions or employment benefits. The one thing that I think was lost on the situation with the Caledonia sheriff, and I want to basically stick up for what Sheriff Shatney did in some regard, is that some of the money that he was awarding, he never felt that he was able to, and I think it's probably true because he was a smaller department, he was never able to fiscally fund retirement and health insurance for his employees. Some of the other larger departments do. They pay into Beamers or they have a separate health insurance. He never did that. So part of those bonuses he gave was in essence, I can't give you health insurance and retirement, but I'm giving you some money that you can pay your health insurance premium, and you can put some money into a 401k if you so choose. Had he not done that, those employees would have, they'd have to be taking that out of their own salary with no employer support. And so, at least to the extent that I know that was part of what Sheriff Shatney did once or twice a year, was to help them with some, and again, I don't want to talk, not necessarily the larger bonuses of salary, because I think that has to be contained, I really do. But that piece of it, I think, was actually appropriate to say, I can't give you health insurance, I can't give you retirement because I can't afford it as a department, but I'm going to give you some money, and if you choose to do that. So this language basically would preclude, as written, would preclude some of that. So definitely put some, as we keep calling the guardrails, I call them bumpers around how they can spend that money. No question that has to be done. No question. But not necessarily don't throw the baby out with the bathwater, because there was some good intent in some of what was being done.
So Annie, it sounded like even in the auditor's response or recommendations, in the light of that revelation of those, on the surface, the eye-popping $400,000 of bonuses, with this, that the sheriff wasn't doing anything that was illegal or against even a policy, because there aren't bumpers, there aren't guardrails, there isn't a model policy that says this is the appropriate way to do this, this is how you would document it, in a way that I think would give us all the sense that there was, some rationale other than just this is what this particular sheriff thinks at this moment is the right thing to do. And I'm wondering if you kind of agree with the auditor's perspective that it's on us to sort of move into a space where there's a more consistent policy adoption.
Yes, absolutely. And I think that's one area where the Sheriff's Association and the department would work very quickly to get a policy in place so that the sheriffs know what they should or should not be doing around this money. The other thing that has come up is the issue of compensation for the sheriff, him or herself. And the question is, you've heard, I think, Sheriff Anderson and perhaps Sheriff Marcoux both testify, like their salary level versus their counterparts in the state police. And I went out and I did some research and tried to look at what would it look like if they were being paid at the same level as a senior, a lieutenant or a major or a captain. What would it look like with similar years of service? You can build a pay grid so their salary is statutorily set, just like a state's attorney's. So if the question is, in addition to their statutory salary, what would they be allowed to take? It may be one of those things where you say, okay, this is the grid. You have 22 years of law enforcement experience. And in that, we're going to compare you to pick one, a captain, so you can go off the grid. You can take, if you earn that money, you can supplement yourself with X. And you might even want to say up to a cap of X. But there are ways to develop compensation plans for the sheriffs that will not have people being upset or concerned about the sheriffs overly enriching themselves.
Questions for Rory or Amy before we wrap up this conversation for today? Representative Hoover.
It still is very murky to me. It's like, at one point earlier, said that the sheriff draws part of the 5% as an administrative fee for monitoring the contracts. That kind of equates to salary. Or does it kind of equate to, if it's the sheriff's contract and it's outside the state business, then is the sheriff running a business where he's compensated? And if that is compensation, then why isn't any of our business?
So there's
That's not been delineated.
That is exactly dead on point, because this construct of a sheriff's department is not found anywhere else in state government. You basically have statutorily established departments that are these public-private entities. And is there, how did the conflict exist? Well, it's set up by statute. You're asking people to chase, the private money through the contracts, yet there's, but we view them as state. We look at them as public officials, which they are, and state people are right. I think Representative Hooper's correct. I'll point out that, for example, the state transport program, of which the state transport deputies are part of our department, that 5% that the sheriff takes in is helping to buy the cars. The state of Vermont does not provide the cars, uniforms, the guns, or send people to the academy to do those jobs. That 5% is helping to pay for that. So it's really, it is exactly as you're saying.
Is the sheriff responsible for, if it's not used for the business, quote unquote? Is the sheriff responsible for paying income tax on it?
If any money you take as compensation as an employee, you have to pay income tax on.
So do we know if that happens? I mean, that sort of is a tipping point if you're paying income tax.
I don't know if the IRS is listening to my check, but I don't know.
I think are you getting at, Representative Cooper, the money that is billed through a contract to cover overhead expenses doesn't go directly to the sheriff as an individual. It comes into the sheriff's office, and then under the current construct, they have the ability to use those funds to compensate staff, to pay for a car, to buy insurance, and also compensate themselves, but they only would get charged income tax when they sort of pay themselves those funds. It's not as if they're not like the sheriff's office isn't a corporation that pays income tax.
If the sheriff builds a contract and includes overhead and compensation in the contract, knowing that there's 5% that is over and above all the contract provisions that goes to the sheriff, then that sort of, it's just very murky. You can argue, I think, weird stuff based on what we've heard so far.
I guess maybe what I would ask is, right now, short of the audits, is there anything that sort of exposes what any of the funds that come into a sheriff's office really get used for?
I mean, the auditor's audits should be able to show you that. And the question that Representative Hooper just asked, it may be better addressed to Sheriff Anderson and Mark Koo in terms of talking about that. So I don't want to go get out over my skis, because it's sort of, I look at it as the analogy in state government, what we've done over the years. Nobody's heart attack about that. But I think that's a better question to address to them. Can I address one other issue?
Yeah, sure.
So the other thing is that I know in this, you're looking at establishing court security through the sheriffs. And I said before, I'm concerned that if it's left specifically just to per diem staff, you're not going to have the consistency and the coverage that you really need. I think incorporating those positions as state employees gives you the consistency the court is saying. The court testified that they can't operate if they don't feel that they can operate without security. I think that's true. Doing that as per diems is going to be really difficult to ensure consistency. We do not have turnover in our positions, our state transport deputies, until they retire. They are with us. We've got a really long tenured group of employees. They're very skilled, and they don't leave those positions. I think establishing these as more secure positions with benefits and would be a better idea wherever they land. I mean, whether they go to the judiciary or wherever, I still think that looking at them as per diems is not necessarily going to achieve what the court wants. And the other thing is, a conversation should be had with the sheriffs and not me as to whether or not, I know the court has said that they need to be level 3 certified. I'm not sure the sheriffs fully agree with that statement. And I think finding level 3 certified people right now is really difficult. You're hearing it from every agency, every law enforcement agency. I think that have a continued conversation with the sheriffs. Is that really necessary or not?
Well, you've given us a lot to think about. We will probably end up having you back as we consider taking up amendments over the next few days. Really appreciate both of you being here with us. We're going to break now for lunch, and committee will be back after the floor. We have testimony scheduled at 3, and then I'd like to have a little bit of time for committee discussion about some of the things that we've heard in testimony so far in the bill that'll help feed into what we can ask Mr. Devlin to do. A draft of